law that's very confused because of the way that the legislation's written. But the legislation it's in the wrong place. I mean, the legislation really, all it does is it guarantees to the forced heir the satisfaction of his legislative, but it calls that collation. It's not collation. It's reduction. Ms. Hebert?
Okay, for prohibited substitution, for double conditional legacy, we have one condition is a suspended condition, and the other condition is a voluntary condition. I'm confused still about who owns the property in the interim, and that in case confuses me more, because they call them both suspended conditions and say that the first person, the client, I think they call it, has a usufruct over the property until the occurrence or failure of the suspended condition, and then thereafter ownership, full ownership vests. You don't have vested ownership when explain who owns what when.
All right. Ms. Hebert is asking a question about double conditional legacies, which you recall we discussed in the context of the prohibition on certain kinds of substitutions as stated in Civil Code Article 1520. And Ms. Hebert is interested in particular in the very fascinating question of who it is who owns the property that's subject to the double conditional, well, it is the object of the double conditional legacy. Who owns it while we're waiting around to see if the condition is going to be fulfilled or if it's going to fail? Well, let's talk first of all about Batten, since you asked about Batten. In the Batten case, as you correctly point out, Ms. Hebert, the court conceives of both of the conditions, the conditions on legacy number 1 and the condition on legacy number 2, as being, I guess you would call them mirror image suspensive conditions. If the wife survives? If the wife survives me by 30 days, then she gets it. If she doesn't survive me by 30 days, then somebody else gets it. The court said those are both suspensive conditions. Of course, once the suspensive condition is fulfilled, our problem is solved, because there will be a retroactive vesting of ownership in whichever one the condition turns out in favor of. But again, your question, and it's an interesting one and it could be important, is in the interim right now, before we have the retroactive vesting of ownership, who's the owner? And the answer in Batten, I think the reason that the court was talking about the spouse's usufruct is the answer is, for the moment, it's the intestate heirs. And the wife, of course, has got her intestate usufruct under 890. Okay. But what about a different case, where it is not two suspensive conditions, but what I would consider to be the more normal case, and what frankly I think was really the case in Batten, and that is mirror image resolutory and suspensive conditions. I give this to you right now, but if you don't outlive me by 30 days, then I give it to somebody else. Well, you're outliving me or not by 30 days now is a resolutory condition on what I'm giving you, but a suspensive condition on whatever else it is that I've given to the other person. Okay, who owns the property right now? You do. Because the one who's got a gift subject to a resolutory condition has full ownership. Remember, a resolutory condition does not affect the obligation in question, and it does not affect the performance of the obligation. So for the time being, the one whose legacy is subject to the resolutory condition would be the owner, not the intestate successors. Mr. Scandrett? Oh, sorry, follow up?
Yeah, okay. So, in theory, one doesn't own and then the other, but really if she owns and then the resolutory condition, if she dies while she was the owner, and within those 30 days, she owned it, but then it's going to go to someone else who now owns it. So, really, we're going from one person owning it to the next, but in theory, because both the effects of the conditions are retroactive.
Yeah, it's the retroactivity, the retroactive dimension of the fulfillment of a condition that enables us to rewrite history, and upon so doing to say, oh no, there was only one owner all the way along.
Okay.
I'll get
Oh,
you Ms.
okay.
Youngblood. Mr. Scandrett, you asking about the same topic or a different topic?
Same one, but the first case, mechanically, I mean, 1521, you have two suspensive conditions. The succession holds on to it because it says it's suspended until,
Mr. Scandrett, there is no such thing as a succession.
okay, the estate holds on to it.
There is no such thing as the estate, not as a person. The only people who can hold on to things are persons. The estate's not a person.
So possession is immediately vested in somebody even though you're waiting for the right to vest?
That would be fair to say. Of course, they're going to be subject to all kinds of duties. But if you can get the property out of the country into Bolivia, you're all right. You know, Mr. Scandrett was asking about the Batten case again with the two suspensive conditions. He wanted to know, well, isn't it the case that the property, for the time being, while we're waiting for the 30-day period to pass, is held by the succession or by the estate? And the answer is no. The only people who hold rights and duties under our law are persons. The estate is not a person. The succession is not a person. The DeCoujas was a person. His successors are persons, but not the others. It has to be held by some successor. And during that interim period, he could conceivably do some really naughty stuff. The solution for those who have the contingent interest, that is the conditional legacy, is to revoke immediately an administration. That will put the control of the property under the administrator, even though, for the time being, the intestate successor will be protected. But that's how we achieve the result. I'm sorry, even though the intestate successor is the owner. That's how we achieve the protective result that you would achieve in a common law jurisdiction simply by saying that the estate is a person and the estate owns the property for the time being. Now, did you have another follow-up question, Ms. Hebert?
Similar, in the Lowney case, Lowney, once the prohibited substitution, the court gave the property to the residual legatee in that case, and I have in my notes that if we have a prohibited substitution, it's null if both the institute and the substitute and the disposition goes intestate.
It wouldn't go intestate.
Okay.
It'll simply, I mean, if we're talking about a prohibited substitution in a donation mortis causa, it could be in an inter vivos. But if it's one in a donation mortis causa, aka a legacy, the legacy simply lapses, and then it accretes where it does under 1591 and following. It might be intestate, but if there's a broader legacy or a universal legacy that's big enough to catch it, that's where it'll go. Ms. Youngblood?
Yes, I was just going to ask how your description of the more common scenario with one resolutory and one suspensive condition, is that different from the vulgar substitution, or is that just a description of the vulgar substitution? I'm trying to figure out when the 6-month requirement applies or doesn't in those scenarios.
Well, the only difference between the double conditional legacy, the kind that I've described, where you've got mirror image, resolutory, and suspensive conditions, the only difference between that and the vulgar substitution is what you might say is a difference of degree. The vulgar substitution is, I give you this, provided that you survive me, period. But if you don't, then I give it to someone else. Well, the double conditional legacy is just it's different from the vulgar in just degree. I now say, I give this to you provided that you not only survive me, but you survive me by X number of days.
But I thought in 1521, for the vulgar substitution, it specifies for a stipulated period for survival, and says that it can't be more than 6 months. So I was trying to figure out if that applies across the board in all of the scenarios. I no longer see the difference in the 1521 between your scenario and the vulgar substitution. Because this one now says, which period shall not exceed 6 months after the testator's death. So conditions of the legacy or trust beneficiary must survive for a stipulated period.
Yes.
Okay. I must just be missing something.
Yeah, I'm not connecting.
I thought that you were saying that the distinction was that in vulgar substitution, it's sort of forever, whereas in your situation, it's for a stipulated period. It sounds to me like this article is saying it always has to be for a stipulated period under 6 months.
No.
No?
1521, to the extent that 1521 is relevant to the analysis of a double conditional legacy, what it does seem to impose is a maximum post-survival period of
Right.
6 months.
Yeah.
It does do that.
Okay, across the board.
Across the board.